case are straightforward. On September 26th of 2020, the defendant, Christopher Whaley, he caught the attention of Officer Hager in Sevier County driving a gold pickup truck. Officer Hager testified that he was exhibited doing exaggerated movements and erratic movements, which is similar behavior of someone, quote unquote, geeking out. Officer Hager also testified that he was shown that the defendant was not wearing a seatbelt at the time and conducted a traffic stop. Upon the traffic stop, the defendant gave Officer Hager his driver's license but failed to give him registration or insurance for the vehicle. At this time, Officer Hager believed that he was under the influence of methamphetamine and asked him to get out of the car. Under an initial search of the vehicle, it was found to have bullets in the driver's side door and on the floorboard and multiple use syringes throughout the car. At this point, the appellant was detained by Officer Hager, and another patrol officer, Officer Jordan Paul, showed up as backup. He went and talked to the defendant, asked him if he had been using methamphetamine because he believed he was under the influence of such substance. The appellant at that time stated that he used the night before but had not used the day of. Officer Hager did testify at trial that the appellant told him there would be multiple syringes in the car. However, Officer Jordan Paul negated that testimony by saying that the appellant never said that. Officer Paul asked the appellant if he could search the vehicle. The defendant told him, well, you're going to do what you're going to do, and so he ran his canine, and the canine alerted on the front passenger door. In the car, they found a zipped black backpack that contained a used syringe and a .22 caliber gun. At this point, officers testified that there was no evidence linking the defendant to the gun other than the gun being in said zipped backpack in the front passenger floorboard of the vehicle. There was other evidence within the backpack that the officers could have looked at. They could have looked at the computer located in the backpack and the phone located in the backpack. But at this time, the officers didn't even ask the defendant if the backpack was his, if the gun was his, or either of those items were his, or reviewed those to see a link or a nexus between the defendant and the backpack at the time. Even with all these holes in the evidence, on March 17, 2022, a jury convicted the defendant of a felon in possession of a firearm.
Were all those holes that you just pointed out to the jury as well?
It is Your Honor, our office was appointed post-trial and pre-sentencing. Through the transcript, it does look to be believed that it was testified that there was a computer in the car, there was a telephone in the car. I believe that the jury did hear that.
But I mean,
yes.
Was the argument made to the jury there was no investigation as to who owned this computer, who owned the backpack, who owned this? Not just an itemized list of what was in the car, but like, did whoever trial counsel was make the argument you're making now to the jury?
It is my belief that the trial counsel did bring up this. He did question the officers very thoroughly of everything missing within the evidence, and still at this time they found a guilty verdict with everything. Again, our office was appointed post-trial and pre-conviction, or pre-sentence, excuse me. Prior to the trial, the state had filed a enhancement notice of enhancing factors and a range notice as a range 3 offender. Our office objected to this, stating that the state used inappropriate convictions to get to a range 3 sentence, and they conceded that he was a range 2 offender. This would put him as a Class B felon on this charge, 12 to 20 years. The defendant, we filed a motion or a sentencing memorandum stating that the minimum sentence would be appropriate in this matter, simply because there's mitigating factors of drug abuse and rehabilitation along with character letters. The state did not put forth any enhancing factors whatsoever, but the court found their own, and the court, through very vocal disdain written in our brief and in the trial in the sentencing transcript, stated that his disdain for firearms led him to give the defendant a 16-year sentence. At this point, Your Honor, our brief talks about 3 separate issues. We are here to argue the first 2 today. The first one is the insufficiency of the evidence presented at trial to uphold the conviction of a felon in possession of a firearm. It is the appellate's position that all the evidence given was insufficient, and is known that the sufficiency of the evidence challenge, it is questioned whether or not, after viewing the evidence most favorable to the prosecution, in the light most favorable to the prosecution, that a rational trier of fact could have found the essential elements to find the crime beyond a reasonable doubt. If that cannot be met, the judgment should be reversed. The proof presented at trial, as I brought up previously, never showed that the defendant had actual possession, except the state tried to show the defendant had constructive possession through the simple proof that there was a gun placed in the front passenger floorboard and a zipped backpack with no identifying factors linking the defendant.
It's a little more than that. I mean, there's bullets in the car. There are syringes, which he acknowledged were his, in the car. There's syringes in the backpack. I mean, so there's a little more than just, and the backpack's, what, no more than 2 feet away from him while he's in the car? You know, it's a little more than just there happens to be a backpack randomly in the car that has a gun in it, isn't there?
Yes, Your Honor, but the bullets themselves, the defendant never confessed that the gun was his. One officer states that the defendant said one thing, that the syringes were in the car, and the other officer negates that statement, saying he never said that at all. So that's up to, it could be one thing, it could be the other. We're taking the stance that he did not admit to that. Plus, there is a note that the defendant was not given Miranda at all. So if the court would consider that when all of these statements were being made. However, to prove constructive possession, a person must knowingly have the power and intention at any given time to exercise dominion or control of an object. The federal courts have stated that the mere presence alone does not show the knowledge, intention, or power to exercise control over the gun to prove constructive possession. So yes, Your Honor, the gun was close to him, but it was in a zip backpack. It was not readily accessible whatsoever, nor did he give any intention that he was the owner of said gun, or there was no identifying factors even in the backpack that law enforcement saw that he was connected to the gun. Further, he did not give the registration, which was one of the issues up at trial at the time. It cannot be proven that he was the owner of the car because he was not. They did not even ask him he was the owner of the car.
He didn't have to own the car to be in constructive possession of the gun.
I understand, Your Honor. There is a case that was by the Sixth Circuit. It's the United States v. Whaley. It is cited in our brief. In that case, the defendant at the time was in a stolen car where he was evading police. When he was found, there was a backpack underneath the driver's seat with a gun loaded in it. Just because it was not his car, they couldn't prove that it was his car, and plus, there was multiple people that could have had access to that car and that they didn't fingerprint the gun. That was a big issue, and they stated that it was not sufficient evidence for a verdict of possession and felon in possession of a firearm. Here, which I failed to mention earlier, they did not fingerprint the gun either. So
again, I go back to the question I asked you at the beginning. All this was pointed out to the jury, and they still came back and resolved all these issues in favor of the state by finding the defendant guilty.
Correct, but we're asking, after a review of the evidence, even in the most light of the favor for the prosecution, that a reasonable trier of fact couldn't have found each and every element of a felon in possession of a firearm beyond a reasonable doubt in this case due to all the holes in it. Because our case is analogous to the very case that I just cited before you, the Sixth Circuit case, where there was no fingerprints here. Anyone could have been in the car, didn't know who the car belonged to. There was nothing identifying him.
The difference between your case and the Bailey case is it was clear in Bailey that the car had just been stolen. There's no proof in this case that the car was stolen.
I understand that point, Your Honor. But again, just because the car wasn't stolen here, it doesn't show that anyone couldn't have had possession of the car before our defendant or anything such as that. So the entirety of the state's proof equated to the defendant driving the gold car with a black backpack on the floor that happened to contain a gun, that there was no identifying evidence to link him to said gun. And so the appellant would ask this court to vacate the decision and remand it back to the trial court. Or in the alternative, the appellant is seeking the court to review the 16-year sentence bestowed upon him by the trial court. The appellant understands that it is an abuse of discretion standard here, and during the trial, the sentencing, the trial court primarily focused upon their personal desire or personal disdain of gun crimes by stating, and I quote, "But convicted felons cannot possess firearms, and I get tired of seeing it come through this court. I get tired of seeing it. There comes a time when people have to grow up, and Mr. Whaley, today is your day." The Sentencing Act encourages the courts to impose the least severe measure necessary to achieve the sentencing purpose. Typically, that is the minimum sentence showed or is to be imposed because the General Assembly has set the minimum length for each felony class to reflect the seriousness of the offense. Here, the minimum sentence for a Range 2 Class B felony would be 12 years. However, when the court put their personal disdain of gun charges into the sentencing, it was inappropriate, and you cannot use that to enhance a sentence, as the legislature has already taken the severity of the offense by assigning the felony classification. And
Trial court consider the purposes and principles of sentencing?
I'm sorry?
Did the trial court consider the purposes and principles of sentencing?
The trial court did make a statement that he could hit him with 20 years, but he chose to hit him with 16 in the middle, but he did not go through the entirety of the purposes of sentencing, no.
I guess we'll see. Of course, if he goes through that, then even a mid-range sentence like this is presumed reasonable.
Correct, Your Honor.
And especially just to add on to that, there's a criminal history here that spans 20 years, so that would justify taking it from the minimum to the middle, would it not?
I understand, Your Honor, and there is a presumption of reasonableness when it's within the range of the felony class. But when a trial court imposes their own personal beliefs, it is inappropriate and should not be used to do so, especially when the state does not file any enhancing factors and the defendant shows mitigating factors that can be used to look at for this purpose.
Those are to be used in the discretion of the court as the court sees fit, correct?
Yes, Your Honor. I understand. So the appellant today would ask you to review the sentence and remand it back to the sentencing, or to the trial court.
All right, thank you, counsel. All right, General.
Good afternoon, Your Honors. Abigail Renard for the state. This court should affirm the defendant's conviction and sentence for possession of a firearm by a convicted felon. First, officers testified at trial that the defendant was driving a truck alone. When they pulled him over and searched the truck, they found a gun in a backpack on the passenger side floorboard within his reach. This evidence is sufficient to support his conviction. Second, the trial court properly exercised its discretion when it imposed a mid-range sentence based on the defendant's extensive criminal history. So first, turning to the sufficiency, here the defendant has only challenged his possession, and viewed in the light most favorable to the state, a jury could reasonably infer the defendant's constructive possession. So the defendant was driving the truck by himself. The gun was in a zipped backpack that was on the passenger side floorboard. The officers both testified that it was within 1.5 to 2 feet of the driver's seat, within arm's reach. All of this testimony is corroborated by body camera video of the officers. It shows the officers speaking to the defendant. The defendant tells them on the body camera that he has syringes on him, and that there may be syringes in the car. And you can see in the videos how close the backpack was to the driver's seat. It's within reach. And the officers also found bullets in the driver's side door and on the floorboards. And again, as you noted, Judge Dyer, he told the officers that there might be needles in the truck. They found needles throughout the truck, and then they also found an uncapped bloody needle inside the backpack where the gun was. viewed in the light most favorable to the state, the jury could infer constructive possession from these facts. To the extent the defendant highlights all of this missing evidence, none of that is required to prove constructive possession here. And essentially all of that evidence goes to weight. The jury, trial counsel did cross-examine the officers about some of that missing evidence. He didn't necessarily go through all of that missing evidence at closing arguments, but he had highlighted it, extensively cross-examining the officers. So the jury knew that there wasn't this evidence necessarily directly connecting the backpack to the defendant, but that's not required here. And viewed in the light most favorable to the state, it established his constructive possession. And the Whaley case, Judge Dyer, again, as you noted, is very distinguishable here because the car was a stolen car. It had been recently stolen. There was evidence that others had been driving the car, and the gun was hidden underneath the driver's seat. There was no evidence that the defendant had looked under the driver's seat, knew what was going on under the driver's seat. There was no real evidence to suggest that, whereas here, again, it's in a backpack sitting right next to him. Turning to the sentencing issue, the trial court properly exercised its discretion here when it imposed a mid-range sentence. As a range 2 offender, the defendant faced 12 to 20 years, and the court imposed a 16-year sentence. And he had an extensive criminal history that was more than 20 years. He had convictions for simple possession, aggravated burglary, various driving offenses, possession of drug paraphernalia, burglary, theft of property, DUI, reckless endangerment, assault, contempt, and several probation violations. The defendant acknowledged several times during the sentencing hearing that this enhancement factor applied to him. And based on this factor alone, the court could have imposed a maximum sentence. Now, to the extent that the court expressed frustration with the frequency of felony gun possession cases, it explicitly did not impose its sentence based on that frustration. The court said that it could have given a 20-year sentence and been perfectly fine with it, but then concluded by saying, I'm not going to do that. I'm going to treat you as what I think is fair based on the law, whether I agree with it or not. And then the court explicitly sentenced the defendant based on his extensive criminal history. There was no abuse of discretion here, and his sentence was richly deserved. And if this court has no questions, we ask that you affirm.
All right,
Thank you.
counsel. All right, rebuttal.
On the sufficiency of the evidence, again, there was no identifying factors within the backpack to relate the gun to the defendant. The defendant did not own the car. We don't know who could have used the car before the defendant used it. Yes, the defendant was alone in the vehicle, but that does not mean that he had been driving for a significant period of time. Someone else could have used the car right before him and left the backpack. The defendant never stated that the backpack was his, never stated anything within the backpack was his, and further, the officers did not review the computer or the phone or anything within the backpack. Yes, there were bloody needles in the car, plus there was one in the backpack itself. The officers did testify that they believed the defendant was under the influence of an intoxicant. They did not do field sobriety. They did not take any blood, which they could have tested the bloody needle against to verify that the backpack was the defendant's. They did not do that. At this time, the appellant would ask the court to vacate the judgment and remand it back to the trial court on insufficient evidence. Thank you.
Thank you, counsel. All right. Okay. All right. Would you call the last case, please?